This is John Lynch again of Lynch Solicitors in Clonmel for another one of our COVID-19 series. This time it's a divorce wrap-up, very quick kind of run back down through issues or areas that I've been dealing with or addressing in the TIP FM legal slot every Tuesday. So the first starting point, or the first point that I would make, is that you need to be ready for divorce. Divorce is a process rather than an event. And what I mean by that is that you literally have to process the whole breakup of a relationship and then transition into a new relationship. And that involves quite a lot of input, which is non-legal input, prior to starting the whole legal process, which is the divorce process. Now, I mentioned divorce because divorce effectively, with the 2-year time period now, is probably the only show in town when it comes to marriage breakup. The fundamental principle starting point that I would say with a divorce is to ensure that you're ready for it. And to ensure that you're ready for it, you may need to deal with the breakup and the emotional fallout from the breakup. This may involve personal counselling, it may involve group counselling, it may involve counselling with the children, but it does involve preparation to deal with divorce. And because the difficulty that I've found over the years is that while one person may be ready, the other person may not be ready. And part of the process is in fact allowing the other person to get to the point where they can actually deal with it. Now, obviously there are always going to be circumstances that no matter what, you're going to get into a conflict situation, and that will involve or may involve court involvement. But what I'm looking at and what I suggest is that things should be done by agreement, if at all possible. That can be done through solicitors, it can be done through mediation, or in fact it can be done through the court process in advance of a court hearing. The second point that I would make is that you don't have to do it in a confrontational way. It can be done by way of a separation agreement, it can be done by way of a negotiated settlement, or you can enter into mediation and mediate an agreement. You can also actually reach agreement between yourselves, and you can do what they call a non-contested or consent divorce. And effectively a consent divorce can be fast-tracked and be dealt with very, very efficiently without any of the fallout that you may have in a contested divorce. One thing to bear in mind, by the way, is that divorce by definition in Ireland is no fault. So what I mean by that is that who's at fault or why the marriage broke up, and whether you agreed to the marriage being broken up is irrelevant as far as the Irish system is concerned. A divorce, once you comply with the criteria that there's no chance of reconciliation, that you're separated and living separate and apart for a period of 2 years, and that proper provision can be made for, or is being made for, all of the parties, the children and the couple, then on those circumstances divorce is an automatic in Ireland. Now, of course, the third part or the third point that I would make is that in any situation, the obligation of the solicitors concerned, the legal people concerned, the judges, the courts, etc., is to comply with the constitutional mandate, which is that proper provision must be made for the parties and for any dependents of the marriage on the breakup. What's proper provision? Well, the legislation sets out a number of things that the court will look at in order to deal with proper provision. The obvious ones are the income, what income people have, what assets people have, what needs they have, what outgoings they have, how long the relationship has been in place, whether there are children of the relationship, what contributions, if any, either the parties made to the relationship, conduct actually is one that does feature in the legislation. However, that conduct, the courts have decided, has to be very, very significantly gross in order to be taken into account. Basically, and there are a couple of kind of general principles. Now, there aren't the full extent of the requirements under the legislation, but there are kind of general kind of guidelines that the court has handed down. It's probably fair to say that where there isn't enough to go around, or just about enough to go around, 50-50 is usually the situation that you're going to see in most situations. Where there is more than enough to go around, inherited assets can be treated differently. Maintenance is an ongoing process. Maintenance can't be fixed for all time by and large, unless it's a lump sum payment. The family home can be dealt with. Usually from a practical point of view, both parties are entitled, by reason of the criteria, to have their accommodation needs addressed. Quite commonly, the family home is usually where the family will stay if the primary carer is one of the parties and there are children to the marriage. Normally the family home would stay in that situation. However, it's not in any way unusual where the family home is of sufficient value for it to be sold and the proceeds divided between the two parties to give them sufficient funds to go about getting their own new place of residence. So when you've looked at being ready for the divorce, when you've looked at dealing with it by way of mediation, by way of negotiation, and when you're aware of what is proper provision or what constitutes proper provision, the other issue, which is probably the primary issue, is the issue of the children. And again, my absolute on that is that if you can at all, you should try and mediate or agree a parenting plan going forward that deals with the practicalities of it. If you can't, well, then there is a mechanism to go into the district court under the Guardianship of Innocence Act, and that is where a lot of matters are dealt with when it comes to children. Again, one would always have to say that if you deal with it by way of mediation and by agreement, that's by far the better way to deal with it. And one kind of comment on that is that under the new legislation now, the issue of guardianship, where the father has lived with the mother for a period of 12 months, 3 months of which after the birth, there's an automatic entitlement there to guardianship. Also, there is a default procedure whereby you sign a declaration and the mother declares the fact that the father is guardian. Often a very good way to deal with a breakup situation in order to continue the integrity of the family after the breakup, separation. The final and last point that I would make, and it obviously isn't the last point that one could make, but the last point that I would make to you is that if you're in any sort of relationship, agreements should be considered. So if you're entering into a marriage and there are assets that need to be protected because there are assets that are controlled by other parties and or you have a stake in them, in those circumstances, you should consider a prenup agreement. If you're living together but not married, you should consider a cohabitation agreement. If you own assets together, you should consider a co-ownership agreement. And again, the old fail-safe, you should always make a will, no matter what the circumstances are, in order to deal with these family situations. And the final sign-off, just by way of cohabitation, is that under the Cohabitation Act 2015, there are certain rights that a cohabiting couple has in the event of the breakup of a cohabitation or in the event of the death of one of the cohabitants. And that's covered by the legislation. It doesn't preclude you entering into an agreement. In fact, I would advise entering into an agreement. But the fallback position is that under the Act, if you take an action within a reasonable period of time, if you're financially dependent, you can make a claim against the other party on the breakup. And there's no such requirement in the case of the death of another party. You can make a claim against their estate. Again, this is John Lynch of Lynch Solicitors, and thank you for listening to me.